Welcome, everybody. I think we might be live on Facebook now. You never know with the technology gods if they're with us today or not. But I'm excited that you're going to be here with us today. We have some exciting news that you've probably heard from the United States Supreme Court. They came out with a decision yesterday that's going to have, I think, a pretty significant impact on your child's education. So we have with us today an attorney because I'm an advocate. So I wanted to make sure we had somebody that had more knowledge and expertise that can help summarize what the decision says. We'll be talking about some of the positive things that we think will be outcomes, but also some questions that, of course, still remain and, you know, maybe reasons why we have to be cautiously optimistic about all this. But before we go further, let's do a tech check and give me a thumbs up if you're live with us and make sure that everybody's seeing and hearing us okay. So I see us on Facebook Live. Oops. And I hear that feedback. So yeah, so we should be set to go. So as I said, we're very lucky that we have an attorney who's nationally recognized. She is a member of the Council of Parent Attorneys and Advocates, as I am. And so I always look to Jennifer as a person that you can get expert advice from. So she practices in Connecticut. And Jennifer, I don't know if you practice in any other states or not.
Just Connecticut.
Okay. So if you want to introduce yourself, and I thought it would be fun to maybe talk about where you were yesterday, what you were doing, as long as it's G-rated, when you when you heard the Supreme Court decision and what your first reactions were.
Yes, very G-rated. I was walking into an IEP meeting. So, well, that doesn't necessarily make it G-rated if you go to some of the ones you and I have been to, right, Charmaine? But yes, I was walking into an IEP meeting and I received word on my phone and was trying to, on my phone, read the decision and try to get a quick summary. And as is almost always the case, I usually go to my COPA people to see if they can give me a quick update. So I quickly popped out a text to a few of the amicus committee members and said, what's the upshot? I just know that they reversed it. And it was unanimous. Tell me, because I'm not walking into this meeting not knowing. And yeah, got a little bit of a snapshot there. And then, of course, after the meeting, pulled over so I could sit and read it. And then couldn't do much there on my phone, but last night was able to delve a little deeper. I'm still going to be reading it many, many, many more times, I'm sure.
Right. Yeah, it's a lot to absorb. And even last night, you know, there was kind of this flurry of texts and emails and Facebook postings. So it's all very new. And so I appreciate Jennifer being willing to come and help us understand all of this. The other thing is we have, you know, as you're viewing this live, or even if you watch it in the replay, if you want, you can type in the comment box any questions or comments that you have, and I'll be checking back on Facebook, the actual Facebook page, and relaying any questions or comments you have to Jennifer. But as I said, this is going to be, you know, just it's breaking news. So you never know exactly what's going to come the next few days or certainly the next months. But I thought it might be helpful to go back and kind of give people context if they've kind of forgotten about this case out of Douglas County in Colorado. So Jennifer, do you want to share the you know, exactly what the position was, or I can give that background information too?
Sure. So this was a case out of the 10th Circuit, a Colorado case. And so what the essence of the dispute was that the 10th Circuit had held in favor of the school district. It was involving a student who has autism, who was not receiving an appropriate program in the public school, and the parents made what's called a unilateral placement, where they placed their child in a private placement and then sought reimbursement from the school district. And the 10th Circuit ultimately held in favor of the school district and said that the standard, and let me back up a little bit, as for people who may not be as familiar, the IDEA, the federal special education laws, require that children receive a free, appropriate public education, FAPE, right? And the million-dollar question is always, what's the A? What's appropriate? Because what's appropriate to me may not be what's appropriate to you, and that's where a lot of the legal disputes really hinge, because we don't have a great definition in the statute of what appropriate means. And the last time the Supreme Court weighed on it before yesterday was in 1983 in a case called Rowley. Rowley basically articulated that the IEP has to be reasonably calculated to produce some benefit. And I had the fortune of watching the oral argument at the United States Supreme Court on this NDRF case. And what was interesting was that the court is answering the question, or attempting to answer the question, of what is appropriate. And Justice Roberts said, you know, the school district wants to argue that Rowley and the IDA require some benefit. And parents want us to say it requires some benefit, you know, and that doesn't really show up in a transcript because it's an intonation, but some benefit versus some benefit is really where a lot of these disputes come in. And so some circuits, not the 10th, but some circuits have articulated standards that are different than that. Meaningful educational benefit is one of them. And the 10th Circuit in this decision said the standard is more than de minimis. De minimis is a Latin phrase that basically means nothing. So more than nothing was the standard, which of course, you don't have to do much to do more than nothing. And so the school district was arguing for a standard, and in oral argument, it even appeared that even they almost were conceding that maybe isn't the right standard, maybe slightly more than that. And the parents were arguing for a higher standard. And the court, in oral argument, you could see the justices struggling, because it's not an easy thing to define what is appropriate. And what the court ultimately decided yesterday is that it's more, they struck down the more than de minimis standard from the 10th Circuit. They said clearly the IDA requires more than that. And that was a tremendous relief to many of us, because had that been articulated as the new standard, we'd be having a very different conversation today, and we'd be very, very concerned about children with disabilities in our public schools, which we already are, but in particular, that would have been a disaster. So they said, no, that's not the standard, and they struck down, unanimously, they struck down that was the proper standard, which is great, and they attempted to articulate something of a standard. And I'll just say, for non-attorneys, whenever you read a decision as a lawyer, you're going to find language that you like, and you're going to find language that you don't like, and that you think the opponent on your case will seize on. It's rare that you read a decision that you're 100% in agreement with or 100% unhappy with. So there's, of course, going to be years and years of litigation of all of us arguing what we think this case means and how it should be applied by a hearing officer or an administrative law judge or a court. So I'm not here saying I think I have all the answers, but they certainly articulated some good language that I think the takeaways are that there's a very strong reference in many parts of the decision to the individual needs of the child. And so we talk about this a lot, Charmaine, the I in IEP, the individualized program, which we don't see as often as we like for children. And the court really spends a lot of time talking about, you need to look at appropriate in light of the kid. What is this child's unique needs? What are this child's unique needs? What does this child need? And whether or not the progress being made or not is appropriate is going to depend on the kid and the circumstances. And there seems to be something of a different attitude from the court about what the standard would be for a child who's passing from grade to grade and being promoted and doing fairly well academically, which was that Rowley case from 1983. Rowley was a student who was advancing from grade to grade and doing well, as opposed to a student who isn't. And that you have to look at those two circumstances somewhat differently. So there's some nice language in it. I've highlighted some that I particularly like, but that was the upshot of the case.
Cool. And I looked, I'm living in Idaho now, but I used to live in Colorado. So when I was looking at the Denver Post, they had a couple of quotations from Jack Robinson, who is the Colorado attorney for the parents. And what Jack had said was that he was, of course, very thrilled with it, that it, is going to have this higher standard that we did not have before. And it's going to put parents at the table to hold the district accountable.
Yeah.
The other quote that he had was, that no longer can the district just kind of go through some kind of procedural checklist and say, yes, he's made progress or she's made progress. But now the district is going to have to be accountable to show that there really is significant progress that the student is making. So I think, those are the positive parts of the decision. The other, go ahead.
No, go ahead. No, keep going.
I was going to say was from Pete Wright last night. He posted on Facebook. And one of the other points that he was making is that he saw this kind of as an additional affirmation that the court prefers inclusion and that we start with that least restrictive environment. And so I hadn't really thought about that aspect of it, but I think that's going to be interesting for us as advocates or attorneys to maybe go back to this decision and also use that when we're trying to get kids more included. So what do you think? Is that like a correct interpretation from me, or?
No, I think that's accurate. I think both Pete and Jack's comments are spot on, and others that I've seen out there. And again, I think we're all just doing our best to absorb it. What I thought was really a nice focus, again, the focus on the individual needs of the child, and that you always need to consider that because, that's so often the problem is that school districts offer what they have, not what the child needs. And so if you have a child who has a learning disability, but is very intelligent and absolutely is entitled to and should be keeping up with the academic rigor of a mainstream classroom, but can't do it with 26 kids at the pace that's happening in the mainstream classroom, but also is not appropriate for the one classroom that school has, which is quote unquote self-contained, for a lot of other reasons. And so what they do is they'll either say you've got to pick one or the other, the inappropriate mainstream program or the inappropriate self-contained program, rather than doing what the law requires, which is to individualize the program for the child. So that was one of my big takeaways, was that focus on individualization. I agree with Pete here and some comments he's made elsewhere since the decision that we're hoping there's going to be more focus on data collection now, on actual progress that you can prove, not just at the end of the annual review, a conclusion by a teacher based on his or her gut that the child's made progress with no data to support that. So that is absolutely one of the important things that I would say as well. And, the statute is the very strong mandate in the IDEA on the least restrictive environment. And I agree that there's some dicta in here that seems to support that the court continues to believe that is absolutely essential and a core component of the IDEA. One of the things that I particularly liked, and it's quoting another decision, so it's not entirely just Andrew F. It actually does quote some from Rowley, but the way that the court incorporated it, I'm just going to read this quote because I really like it. It's when all is said and done, a student offered an educational program providing merely more than de minimis progress from year to year can hardly be said to have been offered an education at all, which I just love that. For children with disabilities, receiving instruction that aims so low would be tantamount to, and this is the quote from Rowley, sitting idly by, awaiting the time when they were old enough to drop out. And, the statistics we have on the dropout rates of students with disabilities and outcomes are not great as it is, even all these years after the passage of the statute. So we're all very hopeful in the community that this decision will give parents the teeth to really focus on outcomes.
Oh, exactly. And we have a question from Yael, who's also a COPA advocate, and she asks, what will this look like in charter schools and perhaps perhaps voucher private schools?
So the voucher issue is an incredibly complicated one, and I'm going to say that for the most part, in most incarnations I've seen, if you take a voucher and go to a private school, you're in you have very few rights, and it's one of the many reasons that those of us who focus on these issues are concerned about that. So I'm going to leave that issue aside because that could be and has been the source of an entire presentation. Not mine. Charter schools, magnet schools, people forget this, including the people who run them, but they are public schools. They are publicly funded schools, and they are as obligated to follow the IDEA as the school that your child would attend if he or she did not have a disability, period. Enforcing it is a conversation, but that's the law.
Oh, exactly. And I think you're spot on as far as, for some reason, the administrators and staff of charter schools often forget that they're actually a public school. And so sometimes that in itself is, a kind of a roadblock for some families. But when we go back to the decision that was made yesterday, one of the other things that we're looking at is, I think a lot of people were hopeful that this new decision was going to overturn Rowley, which, unfortunately, at least in my understanding, it's not. And this is another quote from Pete on his Facebook page. And so I guess one of my questions for you is, so does it look like from this decision that if students can be included in general education with, special ed supports and make, academic progress, go, grade to grade, access to general ed curriculum, is the Rowley definition of, what's appropriate going to be applied there? And then if students aren't fully mainstream, the decision says, then are we going to be using a different set of words and a different criteria, or how do you see this?
I don't think the court went that far to say that there are two standards. They certainly did not overturn Rowley.
Right.
And Rowley is in and of itself very much misunderstood, in my opinion, and often misrepresented, frankly, by school district lawyers. As just one example, Rowley is often cited for the proposition that if a child is being advanced from grade to grade and has decent grades, that they're making progress as by definition. And Rowley does not say that. In fact, Rowley has a footnote that explicitly rejects that argument and says, grades are one factor. But, grades are subjective. A grade is usually based on what a teacher thinks of a child's performance. It's not scientific in the way that standardized tests and other measures are. So the court in Rowley, even in Rowley, said very explicitly, it's one factor. And we do not hold today, and that was 1983, we do not hold today that just because you're moving from grade to grade, that means you're making progress as defined by federal law. So, it's not, I don't think it requires Rowley being overturned to make the decision that the court made yesterday, which really, yes, I do think that there's language in this decision that makes the analysis somewhat different for one type of child versus another. But in another way, I think one could argue that it doesn't, because it is always dependent on the unique needs of the child. And so it's always been a relative consideration to that. So I don't see it as having two distinctly different standards, but it will be interesting to see how it plays out. If ultimately, just as Rowley has played out differently than I think a lot of people would have liked, it'll be interesting to see how Andrew F. plays out.
Right. And I think that's a question that I've heard from some other parents, because depending on, what district you're in, your circuit court could have maybe even given stronger definition for what's, an appropriate education. So do you think if there, for example, there's a couple circuit courts that defined it as meaningful educational benefit. So would those families almost be, kind of have lost a little bit of ground with this new decision, or what do you think?
No, I don't see it that way. And I assumed on your slide just that people know that you were talking about the number of circuits, not which circuit. So you said 2 circuit courts, just so people don't think that that means that's circuit, because
Yeah, that's a good.
I understand your slide. So yeah, so like as an example, you have there it says 2 circuit courts, meaningful educational benefit. I'm in the 2nd Circuit, and we have that standard here. I don't see us losing that, and I'll tell you, or I don't see us losing that by virtue of this decision, I should say, although I'm sure it will be argued. And I'll tell you why, and some of it is basic civics, and the rest of it is just the law in terms of understanding how these cases are decided. So in our system of government, the federal government, when they have a statute like the IDEA, the easy way to look at it is it establishes a floor, not a ceiling. So the state can provide that individuals more protection under their law, but not less, okay? So as an example, a state can, as in Connecticut we do by state law, have the burden of proof in a hearing on the school district to prove that FAPE was offered. In other states, that is not the case. And the Supreme Court has said in a case called Schaefer that as a matter of federal law, it's not required that it is on one side or the other, that absent state law that says what it is, that in most circumstances it will be on whoever filed, the moving party. But Connecticut is elected to go above that, and many, many other states have. And so if we in the 2nd Circuit have a higher standard for school districts, that they have to prove that they've offered a meaningful program, the fact that the federal U.S. Supreme Court made this decision does not necessarily mean that we lose that right. However, it will depend in part on the cases that establish those standards and whether they were interpreting the IDEA alone or if they were interpreting the IDEA as buttressed by some state language and state law and case law. So I am preparing myself as I did after Schaefer. When Schaefer came down, I read it and I said, there's no question that in Connecticut we still have the burden of proof on school districts. But I waited about an hour and a half before some school district lawyer made that argument and ultimately had to litigate it. And the court said, no, Schaefer does not overturn our state law that says that the burden is on the school district. But I fully am preparing myself for the argument to be made probably within any limited period of time this week by some school district attorney that now in Connecticut we don't have to offer meaningful educational programs, but more along the lines of how the Andrew F. Court articulated it. I'm not unhappy with the way the Andrew F. Court articulated it per se. I'm saying I'm expecting that argument because we do have a pretty, the word meaningful is a great word. And of course, many of us would have liked it if the court had adopted it in Andrew F. But we'll just have to see how it shakes out.
Right, right. And I think that's the continual, kind of problem that we all deal with as far as the language and how that's interpreted. So even though we have the Supreme Court case with the decision, we still have language that's going to be up for interpretation. So it's not like, oh, we can relax and this is great. It's like every other legal decision.
Yeah.
It's going to be interpreted in a variety of ways across the country. But
yeah,
it's still, I think all along, and that's why I have my celebration background here, because I was so excited yesterday. So it's like, and it was so funny because I went to the party store to buy these things, and the high school girl that was checking me out said, oh, what are you buying stuff for? And I said, I'm celebrating the Supreme Court decision. And she just kind of looked at me like they had a party supply at the store. And I went on to just give her this simple synopsis. And she said, that's interesting because she said in my high school, the students with more, I think she said, severe disabilities, what they have to do after lunch is they have to go around and pick up all the trash in the lunchroom.
Oh.
Said, I don't understand why that's their education. She said they shouldn't have to be doing that. And it was like, you're right, and it's like, maybe go to student council and, so you guys can help advocate and make a change. So
I would say the inappropriateness of those children's education is the least of my concerns about that scenario, right? That's just bad all around. Yeah.
Right. I mean, yeah, on many levels. But, it was interesting because, here she was working at this party store, and she had a story that, fit in, and she was curious about it. And so it's like, wow, I love when youth are out there and they can rally and help people be more, assertive and being their own self advocates. So that was
right.
that was kind of interesting. The other thing I think that's going to be, happening now is, besides additional litigation, is that now this case is going to go back to the 10th Circuit Court of Appeals, and it's going to be decided on this new standard. So for us that don't understand all of this court procedure, so if you could maybe explain a little bit about what that process will be like now.
So that's what happens when a case is remanded. That's the term, is when the court says the higher court sends it back to the lower court to make a decision based on the facts of the case, consistent with the new legal position that the higher court articulated. That's why, not just in this case, but in many cases that go all the way to the Supreme Court, you'll see, if you try to search the case and you're not a lawyer, it can be really overwhelming, because you may see 7 or 8 different iterations of the same case between the district court case, the circuit court case, the U.S. Supreme Court, then the new circuit court case. So of course, you will be following it. And what you always hope when you see a remand like this, at least I always hope, I hope that the school district lawyer and the parent lawyer can get together and settle this thing, because, it just, at a certain point, you wonder how much more money is spent on the litigation than if the parties had just come to an agreement about the program to begin with. And we see many of these cases where by the time it's actually fully done, the kid's long since graduated, or, is an adult. It can be a little disconcerting. But basically what it means is that it's going back to the 10th Circuit, absent an agreement being reached between the parties. It's going to go back to the 10th Circuit for that court to make a determination about whether or not, based on this new standard, they would rule in favor of the school district or in favor of the parent, which is why some of these cases can become Pyrrhic victories for the family, or for the school district for that matter, because if at a certain point you lose your individual case, but you set a very important legal standard, and we tell parents that sometimes, maybe what you're doing today didn't help your case, or maybe you didn't win, but you've made precedent that will help countless children. And so if it goes back and the parents lose and they don't settle the case, I certainly hope that they carry that with them.
That's true. Yeah, and I think that's what sometimes parents don't understand, is the length of time it can take. I mean, for Drew, it was, the beginning of 5th grade when the district gave the family offer of faith that was pretty much the same IEP that he had for a number of years. So that was the beginning of 5th grade. Well, now he's 17 years old. So it's nothing that, gets resolved easily and quickly. And like you said, the amount of taxpayer money that the district is using to continue to litigate is extraordinary,
Well, and when you think, and I understand that, just as I just made a point that sometimes the precedent is as important as the individual case, I'm sure school district lawyers feel the same way about their issues, that, that they feel strongly that this is a matter that they want to make precedent on, even if it means that for this particular school district or this particular case, it's not necessarily fiscally the wise way to proceed. And I'm sure they convince themselves that it's the way we hold back future financial commitments. Interestingly, though, at oral argument, and in this case, like many, we have the fortune of a situation where a parent was able to provide privately the services that he needed while fighting it out with the school district, which, most families simply can't do. This family was fortunate enough to be able to do that. So the very best news is that he really made great progress with the support the parent provided. And interestingly, the court got that in oral argument. I was thrilled to see a question was posed along the lines of, the cost associated with this and other programs that are rather expensive. And I thought that the parents' attorney handled it quite well on his feet by saying, Congress has contemplated this, and the reason that they're supposed to provide an appropriate program is that we want adults who aren't reliant on the public system. We want them to have skills, and so it's actually the wise thing to do fiscally is to actually educate these children so that they can become independent. And the court, in responding to around that inquiry, said, in this case, it worked. I mean, this child made great progress in this program that the parents provided privately. So, yeah, it's always, whenever and I feel the same way in my office, whenever I have any family where they are able to do it, I think of the thousands and thousands of children whose families can't do it. And those are the tragic cases because they're not arguing about who gets reimbursed for the appropriate program. The child's just not learning.
Right.
And this is worse.
Yeah. Yes. And I think that's what, is frustrating because it's like parents do have procedural safeguards and due process rights, but often it seems like you have to have the financial ability to, take the action for those next steps because they do cost money to, continue your fighting.
Yes, I always say to my clients, I wish there was a special ed 911 I could call when the law was being broken, but it doesn't work that way. Parents are fairly much left to enforce this statute themselves. We're fortunate that not only do we have some wonderful nonprofits and public legal aid opportunities for some families who can't afford private attorneys, but the statute itself does, because it's a civil rights law, and I remind people of that all the time. The statute itself does provide for a parent to be able to recover fees for a private attorney if they win, because you shouldn't have to be affluent to vindicate your rights. That doesn't mean that it's easy to find private counsel who are willing to take that business risk, that financial risk with you. Yeah.
Right. And then just the cost of expert witnesses and things like that. Yeah, but I think
which you can't go back. Right.
I know. But I think, if we look at the news that we got yesterday, and I think everybody was initially just beyond excited. And now that we've had time to read the actual decision, we're contemplating it a little bit more instead of just reacting. So, but I also wanted to tell the people on Facebook Live, if they want a link to the Supreme Court decision, if they want to be able to read it themselves, just to type in the comments, yes, give me the link, and I'll put that link on after our show. And if you have friends that missed the live version of our Facebook Live show today, make sure they know that the replay will also be available for them. So Jennifer, do you have, I know you're running between IEP meetings and everything, but do you have any other closing thoughts to leave with us concerning this new decision?
No, I mean, I'll just say this. I think we're going to have to be vigilant about how this is interpreted. And we, as you said, we can't just suddenly relax and think everything's great. We're still dealing with not only the interpretation of how this particular decision is going to be considered by many different courts and hearing officers, but certainly just across the board, we have good cause to be very wary about the future of special education and the future of special education at the federal level. So I think it's great news. We're thrilled. I'm thrilled it was a unanimous decision. That doesn't happen nearly often enough. And it's nice to get that message, and we needed it right now.
Yes. And for people following along politically, there's also some other connections that happened yesterday that I'm sure you saw on the news. But so it's all interesting how everything's kind of connected here.
Yep.
But, I think I really appreciate you coming on today because you have that insight and that knowledge that helps the rest of us understand all of the legal ease that comes with new Supreme Court decisions. So as I said earlier, there'll be a lot more analysis. I just got an email this morning from somebody at the Supreme Court, their website. They post different updates, and they had a good update in short analysis this morning. So I can also put that link on Facebook if people want to see that update. But thank you again so much, Jennifer. And for other folks, remember our usual time for coming on Facebook is on Thursday evenings at 7 o'clock Mountain Time, but today was our special edition. I wanted to give everybody Jennifer's website so you can connect with her there. And I think I first found out about Jen when I was searching different resources, and the videos that she has that you do with your advocate in your office are so excellent. They're just these short but to the point, give me the bottom line answer here. And so I really encourage people to go over and check out all the resources that you offer families.
Thanks. That's at yourspecialeducationrights.com. That's okay. Where you can find all those videos, and it's free.
Okay, and that's what I thought. It was a different one than your website. So I'll put that link up there too, where they can find the videos. So
fantastic.
Anyway, I hope you have a wonderful day, Jen, and have a great time this evening with your daughter.
Thank you.
That'll be fun experience. And everybody else, stay tuned, and I'm sure we'll have more updates coming. So until next week, take care, everybody. Bye-bye.